In view of the above concept of law, it appears that recommendation of the GST Council to omit Rule 9610 prospectively would apply to all the pending proceedings and cases. However, the contention on behalf of the revenue that petitioners have filed these petitions challenging validity of Rule 9610 cannot be said to be pending proceeding is without any basis, because the petitioner have also challenged the show cause notices as well as the orders in original passed by the respondents by invoking Rule 9610 for rejecting the refund claims of the petitioner, and therefore it can be said that these petitions are nothing but pending proceedings before the court which has not achieved finality when the notification number 20/2024 came into force with effect from 8th October 2024. By notification number 20/2024, Rules 2024 have been notified, and as per the Rule 10 of the said rules, Rule 9610 of the CGST rule has been omitted with prospective effect. This would give rise to three situations. Firstly, the same would be applicable retrospectively. Secondly, prospectively, and thirdly, same would be applicable prospectively but also to pending proceedings. As discussed herein above, Rule 10 of Rules 2024 is applicable prospectively, and the same also would be applicable to pending proceedings. Therefore, we are of the opinion that notification number 20/2024, dated 8th October 2024, would be applicable to all the pending proceedings cases, meaning thereby that Rule 9610 would stand omitted prospectively, but applicable to pending proceedings cases where final adjudication has not taken place. Therefore, in view of the foregoing reasons, the omission of Rule 9610 would apply to all the proceedings, cases, petitions which are pending for adjudication either before this court or before the respondent adjudicating authority, and no further proceedings are required to be carried forward, and petitioners would be entitled to maintain refund claims of IGST paid on export of goods. In view of the above findings, as Rule 9610 would not be applicable to pending proceedings, in view of the omission of Rule 9610 by notification number 20/2024 with effect from 8 October 2024, the question of challenge to the virus and validity of Rule 9610 is not required to be considered at this stage. The petitions therefore succeed in view of the applicability of the notification number 20/2024, whereby Rule 9610 is omitted, and the said notification would be applicable to all the pending proceedings cases as on 8th October 2024. The incurred show cause notices and the orders in original are therefore quashed and set aside. The petitioners are therefore entitled to maintain refund claim for IGST paid for export of goods as per Rule 96 of the CGST rules 2017 in accordance with law. Civil applications also stand disposed of. Rule is made absolute to the aforesaid extent. No order is passed. Know that wherever that Cosmo matters were also part of this group, so we have not given any findings because now nothing survives. Therefore, there is no point in going into whether it is that 53 is prospective or retrospective, because 9610 itself does not. Dispose of those. There are some matters wherein this issue is, this group is pending. So the certain applications are filed to segregate those matters, but now that would not survive. That will take up those applications. Take care.